We are on the record calling 21170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. Your appearances.
Good morning, Your Honor. May it please the court, Suzanne Strickarts, P44018, on behalf of the plaintiff.
And your name, sir?
Kevin Hurst.
Okay, where are we on this file, people?
Your Honor, we had a pretrial. You opened up a written discovery. We did send discovery out. We did receive it back, apparently unopened, indicating there was a written on the envelope itself. It had written, I'm reading here, I do not accept your offer to contract, all rights reserved, UCC 1-308, signed, and then it was a return to sender, Judge.
All right,
So
Mr. Hurst.
we attempted to do discovery anyway. So.
Mr. Hurst, did you refuse to accept the mail?
Did I refuse to accept the mail? Yes.
Sir, you can't do that.
I can refuse to accept any mail that comes to me.
And what the fuck does fruise mean? Are you like having a seizure or something? Because you have to be having a seizure to think that writing an edible highlighter on the outside of your discovery packet that you don't accept it is going to get you out of the legal donkey shit that you put yourself in.
This is what we're going to do. One of the things she sent you were requests for admissions. If you do not provide proper answers to those requests for admissions, they are deemed to be conclusively admitted. Do you understand that, sir?
Objection, Your Honor.
Do you understand what I have said?
No, I don't.
All right, here it is. I open written discovery in this matter. You have a right to whatever legal position you want, but you do not have your own set of court rules. Among the things that the court rules provide when written discovery is open is that she can send you requests for admissions. Those requests for admissions are in writing and they must be answered under oath and in a certain time frame. If they are not answered and filed in accord with the court rules, then they are deemed to be conclusively admitted. You will not be able to contest those things. And that was what was sent to you, sir. And that time to start running those started with the day they were mailed to you.
Your Honor.
You don't want to accept it.
I'm not even sure. I do not have any understanding of this is my debt or not.
And what exactly does freeze even mean? Are you having some kind of episode? Because you'd have to be halfway into a seizure to convince yourself that scribbling an edible highlighter on the outside of your discovery packet, declaring you don't accept it, is somehow going to rescue you from the legal mess you created for yourself. That's not a strategy. That's pure delusion.
Coming with these allegations, I'm trying to see and verify if it is. When they called me the first time, they should have sent out verified documents stating that the original creditor and who it was, and that I truly owe this debt.
Well, Your Honor, I just indicate that we did attach to those.
They already
Excuse me, Mr. Hurst.
Excuse me, I wasn't finished.
Excuse me.
I wasn't finished. I wasn't finished. She cut me off.
You, Mr. Hurst. I'm not going to have this.
Your Honor, she cut me off.
I'm not going to have this.
Talking.
This is not a clown show.
Oh my goodness.
One at a time.
I can finish my statement.
You will speak one. Don't interrupt me again, Mr. Hurst.
Go ahead, sir.
Why, thank you. You will speak one at a time. You will not interrupt each other. You will not interrupt me. Do you understand what I have said? Mr. Hurst.
I don't understand anything.
Okay, fine.
I don't even understand why I'm here.
I'm going to mute you.
I don't even understand what's going on.
What exactly did you think was in that packet you refused? Honestly, rejecting your own discovery packet might be the single dumbest move you've made so far, because it means you're walking straight into trial without knowing the allegations or the evidence stacked against you. You basically chose to blindfold yourself before stepping into the ring.
I'm muting Mr. Hurst, and I will let Ms. Strickard say what it is she wishes to say. Then I will unmute Mr. Hurst and allow Mr. Hurst to speak. Ms. Strickard, you were responding, Mr. Hurst.
Yes, sure. I was just indicating that we did attach the account statements, the full chain of title and seller data sheet to the packet. So even though there was no requirement, we did want to provide that to the defendant. And so that was in all of those materials were in the packet that was rejected, Judge.
Well, let's let Mr. Hurst respond.
Okay, so the understanding that I have is that they should have contacted me 5 days after they should have gave me documents 5 days after they contacted me about the alleged debt. I told them I have no recollection of the debt. Yeah, I don't even know enough information to admit or deny the allegations to the debt. So if they're accusing me of this debt, I would like to ask them a few questions so that they can verify that this debt even belongs to me. And that's why I refuse the packet, because I don't know if they're trying to contract with me or not.
Oh, I don't doubt that for a second. In fact, I'm pretty sure you'd struggle to tie your own shoes without somehow managing to eat one of your socks in the process.
I didn't know what it was, so I sent it back.
All right, let me explain it to you again. Whatever political views you have,
I had no understanding that they were sending me these things. They didn't even tell me that they was going to send me. In the last court date, did they say, or did she say, we're going to send you something?
sir, I opened written discovery. That allows you to serve written discovery. That allows her to serve written discovery, and she did so. If you elect not to receive it, then that's on you. That's the risk, and you bear the risk of that. But I would urge you, and let me tell you, as I told you at the beginning, you have an absolute constitutional right to represent yourself, but what you do not have is a right to your own set of court rules. You may not be frustrating the court rules, sir, by refusing to accept mail. If that's the choice you make, then that's the choice you make, and you will have to live with the consequences of that. I would urge you, sir, perhaps you might want to get counsel, because I don't think you understand the process, and I'm not at all sure you understand the consequences of the choices that you are making. However, as I indicated, you have an absolute constitutional right to represent yourself. I would urge you to get counsel. So I'm going to give you another date. And sir, she is going to do what she does to represent her client, and you're going to do what you do. And if the court rules cut against you,
Trust me when I say this. Sovereign citizens are financial black holes, and no one with even a shred of monetary sanity would ever want to enter into a contract with you.
I got a question. They are claiming that this debt belonged to me. Would they have to produce all the proof and verify that this debt belongs to me?
the plaintiff has the burden of proof, Mr. Hurst.
That's right. So she have to produce the proof that this debt belongs to me, right?
She has the burden of proof.
Okay. Thank you.
All right,
Judge,
I'm sorry, Ms. Rickards?
Your Honor, would it be possible for us to receive a motion date for, say, mid-July?
Let's give him one more opportunity.
Oh, you want me to resend the packet, Judge?
I want you to resend the package. And sir, let me urge you as strongly as I can. So receive and open the package. Because if you do not, the request for admissions will be deemed to be conclusively admitted. The lawsuit, as a practical matter, will be over. Do you understand what I have said to you?
Yeah, I understand. Do you I got a question. Should they have sent me something before they send me this package since the last court date
Sir,
to verify that?
Sir, they're not required. If you think you need some information, you have the right to seek discovery too. But you can't tell them how to litigate their case. The same way
Okay,
they can't
so
tell you.
she's gonna send me a packet and I'm gonna send her back a packet as well, right?
No, you're going to do what you choose to do. She's going to send you again those requests for admissions.
Well, you said the
Don't
discovery
interrupt me again.
for me
We had
and
this
her.
conversation before, didn't
Sorry,
we? We
Go
had
ahead.
this conversation before.
go ahead.
As a courtesy to you, she's going to send you the request for admissions one more time. You will either accept the package or you will not. You will answer and serve the request for admissions in accord with the Michigan court rules, or you will not. And then if you do not, then those things will be deemed to be conclusively admitted. If you choose to send written request for discovery, you have a right to do that too. You can send written interrogatories, request for production of documents, and request for admissions. Same as
Sounds like a fair deal to me. If you want to wreck your own life, go right ahead. Nobody's going to stop you from loading up on paint chips at the breakfast buffet. And it certainly won't be Judge Robinson, who's going to get a genuine laugh at your expense by the end of this video.
All right, we are on the record. This is 21-170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. Your appearance.
Good morning, Your Honor. May it please the court, Suzanne Strickhartz, P44018, on behalf of the plaintiff.
And what is your name, sir?
Kevin Hurst.
Okay. All right.
I do hereby reserve all of my rights, waiving none, not to be compelled to perform under any contract or commercial agreement that I did not enter knowingly, voluntarily, or intentionally. I do not accept the liability of any compelled benefit or unrevealed contract or commercial agreement without prejudice.
Well, he's in the same mess she was. Just without the 8+ years of law school, she had to at least attempt to defend herself. And that wraps up his first appearance. He finally accepted the packet, so now we can move on to the second appearance.
Is there anything else you want to say, Mr. Hurst?
That's it.
All right. All right, where are we on this file?
Judge, discovery's been completed. Motion for summary has been filed. We are looking for the court to assign a date.
Okay. Let's get you guys a date. Mr. Hurst, do you have the motion for summary disposition filed on behalf of the plaintiff?
It looks like this.
What's that?
It looks like this.
I'm asking
Yeah.
you first if you received the motion for summary disposition filed by the plaintiff.
Do I have it?
Yes, sir.
Yes.
Okay. So let's set you a date for hearing and we'll move on. Does July 26th at 10 o'clock, does that work for everybody?
Yep.
Yes, Your Honor.
Okay. July
Thank
26th at 10 o'clock, we will hear the plaintiff's motion for summary disposition. Sir, if you wish to file and serve an answer to that motion for summary disposition, you must do so within the terms provided in the Michigan Court Rules. We'll hear the motion July 26th at 10 o'clock. Again, sir, if you want to file an answer, be sure to serve both the court and the counsel for the other side.
Yeah, he's about to serve them a full plate of nonsense with a side of dumb decision salad. And now we finally get to the part I've been hinting at throughout the entire video. And when I say fun, I mean fun for the judge, not for him. Hamad, I swear, I watched that moment at least 10 times with the biggest grin on my face. And somehow it kept getting bigger every time. All right, guys, that's gonna wrap up the video.
The court has had an opportunity to review the pleadings here. I was particularly interested in the request for admissions that was served by the defendant. Request for admission number 3. Does the plaintiff admit and have proof that the allegations against the respondent are true and accurate with all documentation being verified, signature and seals? These were admitted. Does number 4, does plaintiff admit and or have proof that the statute of limitations has not expired to collect on his alleged debt? Plaintiff admitted that. Does the plaintiff admit number 6 and have proof that the respondent had a meeting of the minds with Credit One Bank pursuant to the contract agreement in respect to full disclosure, and that said contract contains no elements of fraud by Credit One Bank? Plaintiff admits that. In number 7, does the plaintiff admit and have proof that Midland Credit Management purchased this contract from the original creditor and is now the new owner of the alleged contract and of the said debt that is owed? Plaintiff admitted that. So what we have is we have an admissions by our defendant of the validity of the contract, admission by a defendant that Midland creditor is a proper party plaintiff. And then we have in our request for admission number 8, does plaintiff admit and have proof that Credit One Bank did loan their credit to respondent and that the respondent is only obligated to pay back in money to Midland Credit Management? Plaintiff admitted that too. I also note for the record that having reviewed the brief answer to plaintiff's motion for summary disposition, first of all, contrary to court rule, is not supported by an affidavit. 2.116G4 says that when a motion for summary disposition under C10 has been filed and served, the opposing party here would be the defendant, may not rely upon his pleadings, but must by affidavit or as otherwise provided in this rule, demonstrate the existence of genuine issue of material fact. Again, I note for the record, no affidavit was submitted here. I think it's fair to say that the pleading filed by the defendant is somewhat obtuse. I quote, for example, from the third page, the agreed upon proof of claim does not serve in place of the original account, for it is a conditional acceptance and not the foundation of an action, and does not become an original demand and amount to an express promise to pay the actual sum stated. In his first paragraph, the plaintiff, and I'm quoting again, plaintiff claims that the living soul utilizes an address in his answer, when in fact the address that is used there indicates that the living soul does not live at this address, but is receiving mail there. So the defendant has failed to appear. He has failed to support his brief answer to plaintiff's motion for summary disposition by affidavit as required by the court rule. The court has had an opportunity to review the pleadings filed on behalf of the plaintiff in this matter, and I'm satisfied. There's no genuine issue of material fact in this matter. Summary disposition is granted in favor of the plaintiff. If you'd be kind enough to send me your judgment under the 7-day rule, I'd appreciate it.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
All right, counsel, you can please order your client.
Yes, I'd like to direct your attention to June 15th, 2023 and June 22nd, 2003. Did you fail to appear for a probationary instruction?
Yes.
And additionally, while on probation, you did accrue a new charge, correct?
Yes.
Satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, factually accurate. The court will accept your plea to the probation violations. Enter a plea of guilty based upon your, enter a probation violation based upon your plea of guilty, and that would be technical violations 1, 2, 3, 4, and 5. And counsel?
Your Honor, I saw the recommendation for 60 days jail. I asked that my client get credit for the time that she's been in since December 1st. I'd ask that it run concurrent with the admonishment that she's received from the charge that she just took a plea on. And then furthermore, she did ask that during this time in custody, if possible, she would like the opportunity to be tethered to treatment. Thank you, Judge.
All right, Ms. Bolchak, did you request?
This opening sets the stage as the judge confirms the defendant's plea, calls out her missed probation meetings, and reviews the new charge she picked up while already on supervision. Defense tries to soften the blow with a treatment request, but the judge isn't buying it yet.
To be tethered to treatment while you've been on bond?
Yes, just to try to have time. I mean, I don't think I personally need treatment, but I know that that was something that I asked for when I first got arrested. So I'll do the days, I'll do whatever it takes, but I really just want to get home.
Okay, ma'am, let me ask you a couple questions. Number one, if you don't think you need treatment, why did you ask to go to treatment?
I was trying to have like the days made up. I don't know if I don't really know. Because
Ma'am, you asked for treatment, so why did you ask for treatment?
Get out of jail.
I'm sorry?
To not have jail time.
Oh, that's what I thought. Okay, so, and you don't think you need treatment? Given what's been going on with you the last year, you don't think you need treatment?
Honestly, no. I really found myself in here. I've been spending time with myself. I don't know. I don't feel like I need a guy or anything. I don't know. I just want to get going on life.
Well, man, the way you've been going on life, not a great start. How old are you?
25.
25. And now you have 3 drug-related convictions. 3. Your under advisement status is revoked.
Here, the judge presses her hard. He wants to know why she asked for treatment if she claims she doesn't need it. And the truth slips out. She just wanted to avoid jail time. That admission instantly shifts the room. The judge calls out her history, her age, and the repeated failures on probation. Her attempt to sound confident collapses under the weight of her own contradictions.
You had an opportunity to not have your possession charge on your record, and you didn't do a darn thing with probation. Not at all. You just ghosted us.
I know. If I get probation this time, I told myself, like, you know, it would be at least 6 months. That's all I would really need to get like clean, and you know, by summertime I'd be, you know, working. I really want to get a car. But aside from the job thing, just, you know, I want to draw and make music, and I don't know. I just want to do things for myself, and I like coffee again. I don't know, just things I've been drinking a lot of water. There's just a lot of things I wasn't doing before that, like, I've been doing since I've been in here. So I haven't
Hey,
been.
ma'am, part of the concern, right, is when you get out, how are you going to continue to do stuff? Right? That's part of what treatment is, and you don't think you need treatment. So
I've been to court 7 times. I've been to treatment like 7 times. I don't know. I know how to work the program. I know to go to a meeting when I need to. I know there's just different times. I know.
So you go through the motion, you go through the motions. So you just go through the motions, you don't really receive what it is that you're getting.
I really think I've learned a different way. I've been incarcerated this time, ma'am.
This is where the emotional wall breaks. She talks about wanting to change, wanting to work, draw, make music, live clean. But the judge isn't convinced. He hears her out, then moves straight into sentencing. One case revoked, another revoked, stacked jail terms, and every missed opportunity comes back to hit at once. She realizes it's real, and the tension in the courtroom is unmistakable.
I don't know. It feels different. It feels really different. Here's what regarding probation that you but,
Judge, we're ready to hear the sentencing. We are ready to proceed, Judge.
Okay.
Yes, no, man, you're not getting probation, I can tell you that much. The court's going to, on 23405, the court's going to adopt the recommendation, revoke probation, close the case without improvement, $50 probation violation fee, 60 days jail. On 23739, the court's going to adopt the recommendation. Your under advisement status is revoked, your probation is revoked, $50 probation violation fee, 60 days jail. The court will know that will be served concurrent. And then the court's going to also order on 232479, the court's going to order 93 days jail. Credit for your 15 days. That's consecutive with 23739 and 23405.
As the final numbers drop, 138 days, panic takes over. She begs for treatment, for housing help, for anything that isn't jail. But the judge shuts her down instantly. He reminds her she said she didn't need treatment and makes it clear the court can't trust her to follow through. Her last attempt to reverse the situation fails, and the case closes with a final, firm ruling. Thanks for watching. Don't forget to like the video, subscribe to the channel, and we'll see you in the next video.
And the court will suspend your fines and costs on that, on this matter.
What?
Any questions, counsel?
No, Your Honor.
Any questions, ma'am?
So, how many days?
Well, 60 on your probation violations plus 93 plus 15. So that's going to be, I can tell you exactly what that is, ma'am.
They only been walking.
Is there any way I could do treatment?
138 days.
Is there any way I could do treatment?
And you told this court you don't need treatment.
Okay,
No, you told this court, the only reason you said that is because you didn't want to do the jail time.
no, that's
So
not,
you can do the jail time.
ma'am, I'll do treatment.
And quite frankly, ma'am, with your lengthy warrant status and you're absconding from probation, I'm not sure that you would not abscond from your treatment provider.
Ma'am, I can't do 130 days.
Yeah, you said you didn't need treatment.
I do.
The problem was, when I went to sheriff, the people over.
I need help with housing when I get out of here. I'm gonna need.
I'm sorry?
I need help with housing when I leave here. You know, I have my,
Okay, I need that talking in the background to please stop.
somebody in.
My court recorders indicated our record is a mess because of all the talking in the background. And what was that, Ms. Bolchak?
I really don't. I think I need treatment instead.
Ma'am, you were very clear. You've been to treatment 7 times and you don't need treatment anymore.
No, I do.
You know how to work the program.
No, I got a little ahead of myself. That's what I asked for when I first came in. Because I do have a drug.
Judge, potentially, Judge, I know that potentially she might be asking for some sort of mental health treatment, but I understand this docket does need to be moved along. So if necessary, we had to have the matter recalled later in the morning to potentially have it reevaluated. But I understand the docket does need to move along, Your Honor. Thank you, Judge.
Thank you. Ms. Bolchak, I'm not ordering treatment for you at this point because you stated that you don't need treatment and you only asked for it so that you didn't have to do jail time. Given that and the fact that you had absconded from probation with this court, the court is concerned that you're not going to abscond from treatment. So at this point, 138 days is what you're going to serve, ma'am. And we're all done. Thank you. Off the record. Have a good day.